to wrestle with a number of new laws that have had a chilling effect on fundamental rights, that threaten the independence of the judiciary, and adversely impacted our constitutional scheme of government based on the doctrine of separation of powers. First, the Prevention of Terrorism Act 2015, known as POTA. It is guised as a counter-terrorism law, but it targets an ill-defined group of persons. In its suite, POTA resurrects the ISA, which was repealed in 2012. POTA allows for detention without trial of up to 2 years by the order of an administrative board, with the possibility of indeterminate extensions. Critically, POTA has a widely crafted ouster clause that precludes all forms of judicial review of the detention orders. POTA is unnecessary as there are already ample substantive and procedural counter-terrorism laws in our statute books, namely Parts 6 and 6A of the Penal Code, as well as SOSMA. The exigencies of the fight against terrorism can be dealt with through this package of laws, or if necessary, by strengthening them. Next, the amendments to Sedition Act 1948, which were a reneging of the government's promise made in 2012 that the Act would be repealed and replaced with national harmony laws. These amendments should not be brought into force, as they will further imprison thought, speech, and expression. Sedition is still a poorly defined strict liability offence despite the amendments. The sentence of a fine has been abolished. There is now a minimum and maximum sentence of imprisonment ranging from 3 to 20 years. Further, in sentencing for the new offence of aggravated sedition, the judges are prevented from taking into account factors such as first-time offenders, young offenders, and the possibility of conditional discharge or binding over. The amendments therefore interfere with judicial discretion on sentencing and is a serious fetter on judicial functions in criminal matters. I now wish to deal with the National Security Council Bill, which is possibly the most far-reaching law passed by Parliament in 2015. It creates a new statutory entity called the National Security Council and clothes it with enormous executive and emergency-like powers. The NSC is to be the central authority on matters concerning national security, which has not been defined. Critically, on the grounds of national security, the NSC can direct and control vital instrumentalities of government. The NSC Bill further provides that the Prime Minister may, on the advice of the NSC, declare any area in Malaysia, which could include the whole of Malaysia, as a security area on very broad and vague grounds. The initial period of the declaration is 6 months, and the Prime Minister may extend the period of declaration for an unlimited number of times, and therefore for an indeterminate duration of years. The wide executive powers exercisable by the NSC are not under the purview of Articles 149 or 150 of the Federal Constitution. The NSC operates above the Cabinet, and there are no checks and balances to this unbridled executive powers in the hands of the NSC. Thus, the NSC appears to be a law unto itself. Further, the emergency-like powers conferred on the NSC appear to subvert the constitutional role of the Yang di Pertuan Agong in emergency matters, as provided for under Article 150 of the Federal Constitution. The NSC Bill enables the Prime Minister, either unilaterally or to the NSC, to exercise powers that are in effect emergency powers, but without the need for a proclamation of emergency under Article 150. This usurps the powers vested in the Yang di Pertuan Agong in Article 150.